Good morning and Drshtikon to one and all who have participated for the fourth webinar of Drshtikon Talks. I am Dhaval Bhatia from Team Drshtikon. I will set the rules for the webinar. Request you all to keep yourself on mute and also to turn off your video during the session. We would also request you to place your questions in the chat box. If you have any questions or suggestions, please write it on the chat box. All the questions will be answered after the session is over. And if there are any questions which are left out, we will ensure that we respond back to the participants through our email. Any further questions after the session, you can write to us on drshtikon.talks@gmail.com. I would hand over the session to Sheetal Bain to introduce the speaker for the day.
Good morning. Jai Shri Krishna to one and all. On behalf of Team Drshtikon, I, Sheetal Jasrani, welcome you all. Do you wonder sometimes when one plan about making a will, passing one estate to the loved ones, making trusts, etc.? Difficult to find easily. Am I right? So for answers to your questions, today we have Mr. Ashish Bhakta from Mumbai as our speaker. He is a founding partner of ANB Legal, a full-service law firm having their offices in Mumbai, Delhi, and Goa. Ashish has previously been associated with leading Indian and international law firms, including Flatgate LLP, London. Ashish has a diverse practice and he has headed teams on several high profile mergers and acquisitions, private equity, and project finance deals. He has experiences working on media related documents and has advised and negotiated several infrastructure projects. Ashish has successfully handled various dispute resolutions, including international arbitrations, and he regularly practices before various fora, including the courts and tribunals across India and abroad. He he also has been appointed as amicus curiae by the Securities Appellate Tribunal. He has acted as an arbitrator, mediator in various commercial and family disputes. Having worked in India and abroad, he has varied experiences in several issues, including estate planning. Ashish advises on estate planning, testamentary matters, and also setting up trusts and acts as a trustee to several private trusts. He has been a visiting faculty at the KC College of Law, Mumbai, and lectures in IPR curriculum in Siddharth College of Law. He is a speaker on various national and international forums. We are privileged to have him on this forum and we look forward to hear his views and advice on estate planning. Over to you, Ashish.
Hi, everybody. Thank you very much for this kind introduction. I don't know whether it's valid, but yeah, thank you so much for that. Since the organizers who very kindly asked me to be here have set some ground rules as to what should be done, what not, I have one request to the speakers as well. And the request is that I do not want you to just hear me out. I just don't want you to know as to what I'm saying, but I want you to think along with me because that will be the most important part for us today. Also, since this particular topic concerns after one is dead or after the demise of a particular person, there might be something which may sound offensive, but trust me, there is absolutely no intent to go that route at all. Also, what I've done is that I've made a small PPT for you to understand better and for me to enable to explain to you better. With that, I have tried to keep out the legal part as in the sections, the case laws, etc., out of it completely. I've just taken the gist of everything to try to explain to you as a layperson, and please treat me as one. Yeah, thank you. With that, I'll just start the PPT, which I've prepared. So yeah, first of all, before I start the PPT, I would like to tell you that this PPT concerns people from Kutch and the Bhatia community. So I have kept it a little Bhatia and Kutch centric. So if there are any other viewers who are also here, please forgive me for that part. Yeah, I'll go further. Yeah. So let's start with the part that do we even have an estate to plan? Do I even need to plan my estate? You know, the Nando business hai, Nando ghar hai, that is the thought which comes to one's mind. So what I would tell you is that whether you are Maharao Khingraj or whether you're a small family in Kutch or whether you're humble beginnings or you stay in a palace or you stay in a traditional bunga, there is an estate for all of us to plan. We all need to plan an estate, whatever little we have. So please keep that in mind. Further, the biggest question of all, when do I plan my estate? Some people will say, I'm not that old. I'm going to live for a long time to come. Secondly, why should I even think about it right now? Now is not the time for me to think. Some people, while having the discussion with their family, will say, are you waiting for me to die? Or they would even say that everything is yours anyway. Why should I even think about putting it in place or putting anything in place at all. Now, these thoughts are somewhere not warranted because you never know what happens to you when, and with and in that background, it's always better to plan ahead as to what you want to do. You may put your estate planning um, in circulation, you may not, but at the end you need to plan. Yeah, let's go a little further. Now, since this is a Bhatia community, who are the majority of the audience, this great man over here, Vijay Merchant, is one of the icons of the community, and he teaches us something by what he did best, which is play cricket. I will just touch upon the first two. The rest you can read for yourself. That timing is everything, in the sense that when is it that you have to plan your estate? According to me, the timing is now. You need to plan your estate right now. You need to make sure that whatever you have is planned, and you know exactly what you want to do, how you want to do, and the way you want to go about it. Now the second point here, many shots with one can reach the boundary, right? So how do you plan your estate? Usually people say, okay, will banana, I want to make a will. But is the will or the only testamentary document which you can leave behind? Or there are other ways to plan it as well. That is something which we will see. Yeah. Also the other slides or the other points very quickly, that you need to get the estate plan in order to make sure that you're remembered, and you're remembered fondly. You have done what you wanted to do during your lifetime, to make sure that through the generations or through people who come, you have set out the tone for how things are going to come in future, right? Now, this is a little legal part, so just please bear with me over here. Now, what is this? What is a will, right? Now, if you understand a will, not from a legal point of view, but from a simple standard point of view, and that's the reason why I asked you, please think with me. What is a will? A will is what you want to do, right? So when you want to do something, how do you do something is of course the question, but you always have the will to do something going forward. Now, over here, since we are talking about a testamentary will, it is a legal declaration of the intention of what you want to do, which is, who are you? You are the testator. The person who's making the will is the testator. And what does he want to do? He wants to manage his estate after his death. So after his death, how is his estate going to go forth is something which he wants to do. Now, during his lifetime, he may make many wills, he may do whatever he wants, he may even dispose of the property, he or she can dispose of the property as they like, even though it is mentioned in the will. Nobody stops you from disposing of your own property, even though you mentioned in the will, right? Now, going forward about the part that it takes place after the death of a person, who is it who is going to do who is going to carry out your wishes after you're no longer alive? And that is going to be your executors, the people whom you name in the will as your executors or your trustees, who are going to follow what is set out in the will and do what is expected to do. For whom is it going to be done? It is going to be done for the beneficiaries, the people whom you want to give your estate to, right? Now, now when you want to give something after your death, you have to think through a lot of issues as to who are going to be your executors, whom do you trust to be able to carry out your wishes once you are no longer there, and make sure that you give whatever is required to the people whom you want to give. Now, what are the kinds of wills? There are various kinds of wills which come before us. One is a joint will. Now, what is a joint will? A joint will is where two people are executing the same testamentary document or the same legal declaration of their intention. They can do it together, like husband, wife, can do it together, saying that this is our joint will, whereas whatever is ours will go accordingly to the wish as to what we have set out. Second is a conditional will. Now, what is a conditional will? Conditional will is, say for example, you are like one of the things which you are giving out to the beneficiaries is a flat. Now that flat actually is, according to you, should be given not only to your son, but also part should be given to your daughter. What do? In the will, you set out that this flat of mine will go to my son, yes, but along with that, my son needs to make some payment to my daughter. Only when he makes the payment to my daughter, as I've set out in the will this particular asset go to my son. So there are conditions. Simple. See, all the terms are really simple, right? It just happens that they like people tend to complicate it in their own mind. So if you just go by the words and not the legality, it'll be much easier for you to understand. And yeah, you need to think with me. So remember that. Yeah. The third part is about the mutual wills. Now, what is a mutual will? A mutual will, again, simple term, right? It's as simple as that a person A, a person B are entering into a will or executing a will. When they execute the will, they say that if something happens to me, everything goes to person B, or if something happens to person B, it goes to person A. Mutual, simple as that, right? Let's go further. Now, what are the requisites of a will? What is it that you need to do to make sure that your will is legal and binding and is not challenged on any technical or legal ground, right? The first part, what it must have and what it need not have. It must be in writing, yeah, and it must be made by a person who's of sound mind, and it must be made with your free consent. It's your will, right? So you're doing it with all the will you have. So it can't be that somebody's forced you to enter into it. That's one. Secondly, it should be dated and signed by the testator. We already understood who the testator is. The testator is the person who's making the will, right? And thirdly, it should be attested by 2 or more persons. Now, this is one of the most important part where a lot of people tend to get a little confused, but trust me, it's not confusing at all. Yeah, there are 2 people who need 2 witnesses, independent witnesses, who need to sign at the end of the will that they have seen the testator sign at the will to make this will his own. They need not know what are the contents of the will. They need not know what he is given, whom he or she has given it to, who are the beneficiaries, etc. No, nothing like that. They just need to know that this will has been signed by the testator, and they together are present at that time to make sure that they're witnessing. That's enough. Yeah, that the person who is attesting the will or the person who is witnessing it cannot be the beneficiary, because that person, whoever is witnessing it, can be the executor. So one of the executors can be the witness, but not a beneficiary, because if it's a beneficiary, the will won't be termed valid, right? Now, it is what is it? Again, it is a declaration of the testator with respect to his property. Now, that is very different from your letter of wishes as to what is your wish. Like, again, not an offense, but I've seen a couple of wills where they say, okay, like, in one will I've actually read that Minji Babli Ja Lagan Mukesh Swami Narayan Temple mein karna hai. Now, that is not a part of the will, okay? That is actually a part of what you want it to happen, or that is something which you wish. Over here in your will, you need to keep it strictly and strictly only as regards the property and how you would want your property to devolve once you are no longer there. Okay. Now, of course, it should be carried out after a person's death, right? So it is only after your death which it will take effect. It's not going to take in effect right now. Okay. Now, the next part is one of the most important parts which people miss out on quite a lot. to be fair, only yesterday I got a call saying that I know that my mother, who recently passed away, has made a will, but I do not know where it is. How do I get it? I think it's with my brother, but I'm not sure. Now, that is not something which you want to do. If you planned your estate, you made sure that everything is in order, everything is going to go as per your wishes. If you don't, if people don't find where it is kept, it's of no point. So you need to keep your will with somebody whom you know will produce it at the time once you're no longer there. Of course, not immediately once you're no longer there, but after a few days when you're no longer there, and read it out to all the people who are concerned with that particular will. If you do not have any person whom you trust, of course, I'm a lawyer, so I'll tell you, you can keep it with your lawyer. Yeah. Now, the second part. The second part is as regards what it need not be. Now, a lot of people come and ask you, I mean, my will, it needs to be stamped. If it needs to be stamped, what is the stamp paper which is required? Or it needs to be notarized. I need to notarize my will. I've not been able to notarize my will. Or it needs to be registered. Registration is very, very essential for a will. No, all these things are not mandatory at all. You want to stamp a will, go ahead and stamp it. But there is no effect which it's going to have. You want to notarize it, very well, go ahead and notarize it. It's not going to have the effect. As long as you have signed the will with the two witnesses who have been there personally present to make sure that you signed the will, your will is valid. There's no notarization required. Registration is a little bit of an gray area, or not gray area, but it's a little bit of your own wish that if you want to get your will registered, to make sure that it is not going to be challenged at a later date as regards your authenticity of the will, go ahead and do it. But it is not mandatory. It is not required to be done. Okay. Now, going by this COVID-19 situation, and the courts are going all digital, and we have court hearings by way of a VC, etc. Not only in the high courts but in the Supreme Courts everywhere. There are various questions which come up that why can't I make a digital will? Everything is becoming digital. I'll also make a digital will. There is a issue over there. According to me, you cannot make a digital will because any contract which is entered into online is under the Information Technology Act, and that does not include wills. That is one. Secondly, the part which I've harped on quite a lot, and sorry, but it's really important, that the witnesses should be personally present when the testator is affixing his signature on the will. So that cannot be possible in terms of your Zoom calls or your any other calls. They need to be personally present. And thirdly, digital signatures is not permitted when it comes to a will. So you cannot digitally sign your will and say that, I've signed it, now what? No, you need to personally sign it. And yeah, in writing, just one clarification. In writing, yes, but it need not be with your own handwriting. It could be typed and you could sign it later. So that's one part. Yeah, I'll go further. Yeah. Now, there are various classes of assets which you would want to give in your will. Okay. Before that, let me come to some keywords of the parts of a will, which is essential for us to understand the will as a whole. One is lifetime interest. What is a lifetime interest? Again, it's not complicated at all. It's a simple term, simple English word, lifetime interest. I want to give the lifetime interest to my wife, and once my wife passes away, I want to give this estate or whatever is the asset to my son absolutely. What is it? Simple. That till my wife is alive, she is entitled to that particular asset. She can reside over there. Nobody can tamper with that asset till the time she's alive. Once something happens to her, yes, this can be given to my son absolutely. That is one of the crux when it comes to giving your bequest, or when it comes to giving things to your beneficiary. The other part which most of the wills, at least I have seen, leave out is the rest and residue clause. Now, what is a rest and residue clause? Again, simple English. whatever is left out from your will. Some people make a huge list, Annexure 1, Annexure 2, of my jewelry, of my shares, of my mutual funds, bank accounts. No, all that is not that required. But even if you make that particular annexure, there might be something which may be left out. You might, you are alive from the date you made the will till the time you die. You might buy something, you might get something new, you might be gifted with something, right? So what happens to that part which is not included in your will? That part is a rest and residue clause, and you need to put that part stating that any rest and residue of my property which is not set out in the will above will go to my XYZ beneficiary, or will go to my XYZ beneficiaries equally, or the way you will want to do it. Okay. Now it comes to certain classes of assets, and this is something which the organizers have very kindly made a suggestion for me to add to this presentation, which is the class of assets. Now, if you have, say for example, there is a testator who has two daughters, and he wants to give his one property, which is a farmhouse, to one daughter, and wants to give his flat, which is lying in Bombay, to the other. What will the person do? The person say, I am a very fair person. I want to give both of them equally. Very well. What do you do with that equal part? You take the farmhouse and you get it valued. You go and get the flat valued. Say that the value of both of them is the same. Very well. And you go ahead and bequeath it. Is it that the value of both is going to remain the same? Or could it be that there might be some additional expenditure which may come into either of the assets? It is quite possible. Say, for example, the flat which is there in a city like Bombay, because of the corrosion, there might be certain repairs which will be required to it, or something or the other which will be required to it. So if you are planning to give everything equally, you need to think about how equal you want it to be. That's one. Secondly, as regards shares or mutual funds, yeah, my mutual funds today, the NAV value is so much, the share value is so much, I'm giving it equally. Yes, very well. But again, we have to remember that we are alive from the time we make the will till the time we actually pass away. So just make sure that you are doing what you are doing is thought through. You have clarity of thought when you're thinking through whatever you want. Same as regards your jewelry. Like, say for example, you say, I want to give my jewelry equally to my daughter, or say to my two daughters. Now, what is equally? Equally is at some point after you're gone, they will want to value the say the jewelry. The jewelry is valued. It is figured out that it's, say for example, for 200 rupees. I'm not saying it's for 200, but as an example, it's 200 rupees. One part of the jewelry is for 75 and the other part is for the rest of the amount. How is it going to be distributed? Who is going to pay whom? These are things which you need to think about when you are doing the distribution in your mind and then putting it down in your bill. Yeah. Let's go further. Now we've spoken about the will, and to see what happens when we make the will, or how, or what do we want to do when we make the will. Now, what happens if you do not make a will? The answer over here, of course, is that you will be the assets will devolve as to the personal laws of the deceased person. Now, there are various personal laws. There are Parsi laws, there are Mohammedan laws, there are other laws which are in place. I do not know of any of those laws very well, so I will not want to comment on that. The laws which I know of are the Hindu laws, and the Hindu laws are here in front of you, which says that there is a different devolution when it comes to male and a different one when it comes to female. The first part which you can see on your screen is that if a person dies intestate or without making a will, it will go equally to the first part in terms of a male, son, daughter, widow, mother, etc. In terms of a female, husband, sons, daughters, etc. If the class 1 is not there, or the first line isn't there, it goes to the second. Thereafter, if the second isn't there, it goes to the third, and so on and so forth. Right? So this is something which Of course, it depends from a person to person if the will is not made. Now, yeah, family. Yeah, that is a bane and a boon for, I'm sure, all the listeners and everybody over here. Now, you you may have a hum do hamare do type family, which is small family. You don't have to worry too much. You just made a simple will that everything goes to my son, so much goes to my daughter, equally, or however you want it. It's all done. So much goes to my wife, all done. But what if you have grandchildren? What if you want to make sure that no, my daughter, I need to make sure that my daughter gets X amount of money when she gets married, or my daughter is educated to a particular level, even though I'm not there, and that should come out from my estate. Other than that, there are other things which we want to do. We want to give something for charity. We might want to give people, to various organizations across. So how do we do that? Now this gets a little, I won't say complicated, but this gets a little thinking involved on everybody's part as to what they want to do, especially when your assets could be spread out on various locations. Like you would have been working, say, for example, in the UK for a couple of years, or maybe for more than that, and you have a small house there, and you want to make sure that that house goes to your daughter. How do you do that? That's I will come to that in the next slide. Before I come to that part, there is one thing which is a very common thing which amongst a lot of people, which is I will make sure that my generations after me are looked after. I have worked so much, I have so much that my generations are going to look after, and I from heaven am going to look through them to make sure that they are happy with the estate I pass on to them. Now, it's possible, yes, but it's possible only to an extent. Only to an extent. And that extent is called the rule of perpetuity. I don't want to give you too much legal knowledge over here, but that is something which is in the Transfer of Property Act as well as in your Indian Succession Act. It says that if you are giving something to an unborn person, that person the that it should be given till the time the person reaches an age of 18, and once you're giving that person something, it should be absolute and cannot be limited. Now what does that mean? Absolute lifetime interest is something which we've already spoken earlier. This means that you cannot say that, that my generations after my generations are going to be happy or going to live by the estate which I have. You cannot lock up anything. Now that is the intent of both the sections or both the statutes which are there, which is the Transfer of Property as well as the Indian Succession Act. But you cannot lock up everything. You have to make sure that it is given and given in a particular time limit and in a particular manner, right? So this is one thing which you must keep in mind, which is giving something to an unborn child. It should be given till the time the unborn child becomes 18. It should be absolute. It cannot be a lifetime interest. Yeah. Now, we saw the great Vijay Merchant, right, teaching us something, and that he taught us that there are various ways to reach the boundary. So, what are the other ways apart from the will, which we've already seen? The other things, the other manner in which you can plan your estate is a trust. Now, again, let's not get complicated that trust is runs from the Indian Trust Act 1882. It has various it has various sections, what a trustee can do, what cannot do. No, we don't need to get into that at all. Let's think of it from a simple English term, which is trust, bharoso, right, as we say. Now, why is a trust required? Why would you want to even get into a trust, and why doesn't a will suffice sometimes? But it there are various reasons why a person requires trust. One, as regards NRIs having assets abroad, if you have families which are beneficiaries which are abroad, you don't want to pay the high amount of estate duty which is there in USA and UK. You want to make sure that your assets are protected. There might be cases where there is a special child and you want to make sure that that special child is looked after even after you're gone. Right? There might be other tax implications which you want to look at. I'm not somebody who understands so much tax, but there are various tax implications which a person will want to look at when you're forming a trust. Also, you want to do something in terms of charity. Now, this is one misconception which is there amongst a few people, which I would want to clarify. That if you want to make a trust for public charity, you need to make that trust as a separate entity which comes under a public trust. If you're making a trust only for the sake of charity, right? That is a public trust because you're doing good to public and it will be a public trust. If you want to put a part of your estate towards a trust, you got to make sure that you are bequeathing or giving a donation to another trust to make sure that particular trust receives whatever grant you want, right? So if you say that I'm making a trust, a private trust, and in that trust I want to run a school which will teach Sanskrit to all the students in Anjar and Kutch and in Nadia and in various places of Kutch. For that, you need to make a separate entity which is a public trust which runs for the welfare of the public. Yeah. Good. Now, what is a typical trust structure? Now, we've already seen what a typical will structure is, right? Which is a testator with the executors, with the beneficiaries, right? Now, what is a typical trust? A typical structure when it comes to a trust? When it comes to a trust, it is settlor. So the testator whom we spoke about, because over here, in effect, for the only for the purpose of understanding, becomes a settlor. He or she is the one who makes the trust, right? The trust is the entity which governs it, in the sense that whatever a settlor has wanted to do has now become a form of an entity, a separate legal entity which will govern the entire wishes of the settlor. Now, it's just akin to a company. How you have a company? I've made a company. With that company, it is a separate legal entity. I've already formed the company as a promoter. But thereafter, the company is going to run as a separate entity, not that much concerned with what I want, but is going to be run in a manner with the board of directors when it comes to a company. Over here, the board of directors or something akin to the board of directors will be your trustees, the people who will administer the trust going forward, who will make sure that the trust is run in a manner in which it is expected to run or as per the wishes of the settlor or even otherwise, which we'll come to later. Shareholders in a company over here are the beneficiaries, the people who will be ultimately entitled to what the benefits of the trust are. Right? Now, how can a trust be formed? A trust can be formed by various ways. It can be formed by a will, or there can be a deed of trust, which you enter into, setting out who the trustees, beneficiaries, etc., etc. The trust can be revocable as well as irrevocable. In the sense, you can say that tomorrow the trust will no longer be there. I can revoke the trust whenever I want, or there can be a revocable or it'll be an irrevocable trust. That once I've made the trust, there can be no looking back. This trust will remain as it is. Then there's a discretionary trust and there's a specific trust. What is a discretionary and a specific trust? Discretionary, again, simple English term, that it is left up to the discretion of the trustees as to how they want this trust to function. Giving you an example, say for example, I want to, like a testator or a settler wants to give something to his daughter for marriage and wants to keep something for her education as well. He says, I've kept 500 rupees in the trust as regards this particular purpose or this particular intent which I have, both of them put together. Now, it's a discretionary trust. If it's a discretionary trust, the trustees will say, fine, I will give 100 rupees towards towards the marriage, and the rest of 400 rupees will go towards the education of this girl. If it's a specific trust, the settler will set out that I want 150 rupees exactly to go towards the marriage, and the rest should go towards education. So it's simple, right? It's a discretionary specific trust. Again, you can have a mixture of it. You can have a revocable one which is specific. You can have a irrevocable one which is discretionary. So there's no hard or fast rule to that at all. Now, to revoke or not to revoke, what is the question? Now, whether to revoke or not to revoke, of course, depends on you. It depends on what you want to do, right? But there are various instances or various implications when it comes to tax. Because if it's a revocable trust, it will be trust as per the settler. If it's an irrevocable trust, the tax effect will be as a trust as a separate legal entity, right? Now, even if it's a revocable trust, on the demise of the settler, it becomes an irrevocable one. So that is something which you need to take care of. Okay? Now, in a trust, there's something known as a protector. Who is a protector? Now, it is a little bit of history which I would not like to go into, because there was some tax exemptions when it came to protectors, etc. And so settlers would take the role of a protector in the trust to make sure that they get some tax implication. Of course, that is no longer there right now, so we don't even need to go into that aspect at all. A protector is somebody who looks over the trustees as well, in the sense that you have 3 trustees, but you're not sure whether the third trustee which you put is actually capable of trust, or he might just do something which will not go well with what you have planned. What do you do then? You put a protector, or as if I'm using the term correctly, as Bhatias would term it, Vadabha or Vadab or something like that, right? Who will look after the entire trust and has the powers which are set out in the trust deed or in the will, depending on how you have made your trust, or how you formed your trust, to say that there are various that if there is a trustee who is not adhering to certain norms, can be removed, can be replaced, yeah. Then as regards the termination of the trust, that now the purpose for which the trust has been formed is now no longer in place, and we want to make the trust come to an end, yes, you can give these powers to a protector. The protector can be, of course, somebody whom you trust even more than the trustees. Now, this is something uh, which is when it comes to understanding as regards individual trustees as well as corporate trustees. Now, what are corporate trustees? Very briefly, I don't think I have too much time, so I'll very quickly tell you what corporate trustees are. Corporate trustees are professional people who take up the role of not only a trustee but also of an executor when it comes to running of a trust or making sure that your will goes as per the wishes and norms which you have. Now, there are various differences between an individual trustee and a corporate trustee. As regards, of course, one of the main differences would be that the individual trustee, there's no continuity. You never know. We all don't never know when a life is going to end, right? So in terms of a corporate trustee, there will be continuity. It won't only be that particular individual, but it will be the other people as well. As regards a professional approach, a, a, a corporate trustee will always have a professional manner in keeping your accounts, in keeping all the records, making sure what has to go to the beneficiary has gone, etc., etc. Individual trustee may or may not get the time to do that in today's time, right? So I've already put what all are the various differences between a corporate trustee or a corporate executor, as the case may be, on the screen, and I'm sure you all are having a look and reading it. So I won't go further than this. Yeah. Hello. Can everybody hear me? Am I audible?
Yeah, perfectly, Ashish bhai.
Oh, so I'm so sorry. I thought maybe I've lost the screen, so that's the reason why I'm.
Oh, no. I thought you were waiting to change. Please
No, no,
continue,
no,
Ashish bhai.
no.
Please
Sorry.
continue.
Yeah. I'm sorry for that. Yeah. So this screen was there for everybody to read. I'm sure you had a look at the screen as regards the differences between a corporate and an individual trustee. Now, again, the beneficiaries can be placed anywhere. They can be in India, they can be abroad. The testator or the settler can be in India, they can be abroad. The assets which are which one wants to bequeath can be in India or can be abroad. It is a whole bunch of uh, permutations and combinations which come into place, and that is something which I'm sorry, but in the short time which I have, would not be able to explain that much in detail. So, but it's a whole separate world out there as regards when it comes to a NRI or a non-resident Indian or a person of Indian origin, etc. And this is something which I've spoken to the organizers who are very uh, um, like who told me that it's okay if I do not get into these issues too much. Yeah. So only very quickly telling you that an NRI of Indian origin can inherit any immovable property in India, whether it is residential, commercial, or even agricultural, if it is done by way of inheritance, if it's done by way of a will. And the same way, vice versa, goes the other way around. That a person resident in India can hold any immovable property, etc., abroad if it has been validly inherited to that particular gentleman. Yeah. Having said that, if there are any NRI viewers or any viewers you're from abroad, I'm so sorry. I've not been able to get into too much detail over here because it's a completely different world. And if you have any questions, I'll be happy to take that. Yeah. Yeah. Going forward now, again, many ways to reach the boundary, right? So we've understood how wills function. We've understood how trusts function. What are the structures of the trust? How is it that you would want to give a trust to give your assets to various beneficiaries? What is the trustee? What is a protector, etc. But the third part in which you can give your property away or plan your estate, not give your property away. That's a wrong term. I'm sorry for that. Is by way of a gift, right? Now, what is it? What is a gift? Legally, a gift is given out of love and affection. Okay? It's not only generally, but it's even legally. You need to give a gift out of love and affection because the document which you execute to give a gift, okay, needs to have that clause there that it is given out of love and affection, and it is not given for any consideration whatsoever. The difference between a will and a gift, one of the differences is that a gift is given between living people. I am alive today. I am giving a gift to my daughter to make sure that I want to give it to her today. It is not going to take effect after my death as a will would. It's going to take effect today, right? Now, if you're giving a gift of immovable property, flat, farmhouse, whatever you have, it needs to be registered. If the deed or the deed of gift, as it's called, needs to be registered, it needs to be stamped. Now, that stamp paper or the stamp duty which you need to pay will depend on whom you're giving the gift to and where is the asset located. The asset is located in Bombay, and you, as a father, are giving gift to your daughter. There's minimum stamp duty you need to pay, right? But if as a brother you're giving it to your brother, then there is an amount of stamp duty which will be payable, right? So it all depends on whom you want to give the gift to, or what is the level of relationship which you have as regards the person to whom you are gifting, right? Now, now this the one of the most important parts of a gift, okay, in a deed or even otherwise, and legally speaking, is that once the person gives the gift, the person to whom it is being gifted, which is the donor and donee, the donee should accept it. If the donee does not accept the gift, it is not a valid gift. It's not that I will enter into a gift deed. No, that gift deed needs to be signed by the person whom you're giving it to as well, right? So that is the part of a gift. So to sum up the entire thing, no, sorry, I don't have to sum it up. There's still one thing which I really need to tell you, and this, according to me, is the most essential part, because to make a will, you might get professionals, you might get people who might help you to draft it, but what you do or what is in your mind is most essential, right? So this part, I'm going to read out each point over here for you, so that hopefully you'll take it along with you even after this session. The first is framing your thoughts. If you have something to say it, okay? But think through it whether it is required to be mentioned in the will or not. If you don't need to mention it in the will, do not mention it, because you have to think this is going to be read out after you're no longer there. Yeah. Keep all the related material together. In a sense, if you're thinking, divide it in proper sections. You want to give your immovable property, say, I have immovable property situated over here, and here. This property will go to my son and daughter. This property will go to my wife and daughter. This property will go to my daughter and son. That's it, right? So please put it according to a particular section, so there's no ambiguity when it comes to understanding which asset it is and to whom it's going. Yeah? Apart from that, end your sentences properly. Like, do not just leave it haphazard. Now, this property goes to this person. No. Now, this property, which is situated over here, will go to this person and will go absolutely. Or this person has a lifetime interest in this particular property, after which it will go absolutely to this person. Please be extremely clear in your thoughts. And apart from being clear in your thoughts, that clarity of thought should also come out in your sentences, in your words, which you're using in the will. You have to identify the asset. You have to do it to make sure that there is no ambiguity going forward. You can't say that Minjo Hapolijo farmhouse should go to this person. No. Yes, you are the only asset you have in Khapoli is the farmhouse. Understandable, no problem. But it is better to set it out clearly. Khapoli, which is set out in the schedule hereunder, would go to XYZ. Much better. Refer people to actual names. Very, very essential. You have no idea the kind of ruckus or the kind of disputes which are created because of people using pet names. Minche bubbly ke aao ED. Now, who is bubbly? You might be having 3 daughters, right? So so please use the names specifically, whatever the name is. Yeah. Shun acronyms. Please don't use acronyms that uh, my company HUL will be given. The shares in HUL will be given to this particular person. HUL is what, right? Yeah, you will own the only shares you will be having will be in Hindustan Lever. I'm not saying no, but please mention it specifically, because you never know what are the assets you buy or what are the assets which are left with you when you actually are no longer there, right? Now, another thing is that whatever you are saying, right, whatever you are saying, make it possible that it is written in the same manner in which you're saying. But a person who does not understand, that's a cardinal rule of any drafting, be it will or otherwise, that clarity is most important, right? And over here, specifically because there is nobody who is going to be able to clarify as to what you have written, right? Or what were your wishes or what you wanted to set up. You cannot say, I have told him that this was what it was. Now, why should I bother? If there's any problem, we'll clarify. Please don't do that. Don't keep anything for later. Nothing at all. Yeah. Now, with just to sum up whatever I have told you, is that no one size fits all. You cannot say that, अरे हम मुझे बाजू वाले जो will का नहीं काढ़े उन्हें पता ही काढ़े ठीक है मुझे will. No, you can't do that, right? In law and life or in any profession, when you see, the most crucial words are it depends. Nothing is as it is, right? So please see what works for you and make it accordingly. Plan your estate accordingly. Whether you want a will, whether you want a gift, whether you want whatever whatever is your mode of reaching the boundary. Yeah. Then plan as per your requirement. Whatever you're doing to make sure that there are no conflicts in your family going forward. The biggest kind of conflicts are the family conflicts. Make sure that there are none, or as far as you can ensure that there are none. Right? Yeah. Do as you depict. This is my wish. This is my asset. I will do it the way I want. I need to do it because of this. I need to do it because of that. No, please don't do that. Whatever is your wish, do it accordingly. You be the judge. You be the king of your own kingdom. Distribute the manner in which you think is right. Yeah. With that, thank you so much. I hope it's been something which has made you think, and I hope that it will make you think going forward as well. Thank you so much, everybody. Prashant bhai, over to you.
Thank you, Ashish bhai. Such a lucid presentation, and true to your explanation that the will has to be simple. You kept the explanation and the webinar so simple. It's very, sometimes when legal professionals speak, it's very easy to get confused with the legal language. But you made sure that it was in layman terms and very easy for us to understand. And you underlined the importance in such a good way. I think most of us will remember for a long time. Just continuing with what you said about people who have not made wills and have the family has got issues. Well, the testator tries his best during his lifetime to earn a lot of money. And then if there is no will and the successors have to fight it out, it's a very pathetic thing. Like what happened in Abraham Lincoln's case. Well, it's of the 19th century, but Abraham Lincoln, being a lawyer himself, died without a will. Or for that matter, even the famous musician Tom Hendricks and Bob Marley. $30 million of 30 million US dollars of estate gone down the drain, or not down the drain, but a lot of fights before it could get settled.
Absolutely.
And I think one of the examples you gave was make sure that the will is found easily, and is very clearly said it is at so and so place. Michael Jackson, when he died, there was a lot of fight for his property. Till I think a couple of years or a year later, when they saw his will and they realized, no, the will is there, so we take it from there.
Right,
so excellent presentation, Ashish bhai, and there is a deluge of questions which you will have to take time and answer.
Sure.
So yeah, let me start with the first one. The first one is by Umesh bhai, and he would like to know what is the perfect time to make a will. What is the right time to make a will, and is making a will enough, or is making a nominee enough, or is a will required? In fact, there are a couple of questions about a nomination and a will. So maybe you could throw some light on both.
You know what? Actually, honestly speaking, I had one slide as regards nominations. I had a slide as regards, a lot of other issues as regards probate and letters of administration, etc. I don't know where that slide went. So thank you very much for the question. The first question I'll answer is: a will can be made at any time. You can change the will as many times as you want. You can make changes to the will. You can make new wills. You can dispose of your old will. Make a codicil, which will be what is a document which adds on to your will. So making the right time to make the will, according to me, is now, to make sure that you have everything in place. With the times and the lives we live in, nothing is certain, and it's not only now, it's always been uncertain. So it's always essential for you to make a will. And as Vijay Merchant said, timing is everything. How you want to time it, it's according to you. As regards nomination, I'm really sorry, I don't know why that slide did not come in place. Nomination is something, yes, you made a nomination in favor of somebody, but if your will overrides that nomination, then there is no question for you to say that, or for the nominee to say that, hey, this person had given it to me, I was the nominee. No, it doesn't work that way. A will always override nomination. If you are the nominee and anything has been transferred onto you, and there is a dispute as regards that particular asset, because it's a difference between the will and between the nominee, what you would need to do is you need to hold that particular asset in trust with you. Make sure you do not do anything with the property till the time it is settled as to who that asset is going to be entitled to, or who is going to be entitled to that asset.
So it would be right to say that the nominee is only a custodian. He is not the owner of the asset.
Yes, he's not the owner of the asset, unless, of course, yes, it works smoothly if the same person in the will is the nominee. If it works that way, it's great for you, because then you know that unless a will is challenged or it goes into some dispute, etc., and the will is taken as it is, you are the person who is entitled to that particular asset.
Okay. Rajan Bhai wants to know that if a will is made through video, if a person is not able to pen it down, and if he makes it through video and the recording is available, is that will valid?
No. That's what I mentioned in one of the slides, that in this digitalization world, you still need to follow the rules of the Indian Succession Act. Yeah, you need to make sure that the will is written down, it is signed in person, the executors, the beneficiaries have been mentioned there clearly, and secondly, that the witnesses are there to sign, to see you sign and put the stamp, and to make sure that you sign that particular bill. So no, sorry, it doesn't work that way.
Okay. Ramesh Bhai Ved has a question. If you have a disputed property, can you make a will for one, or how do you make a will for disputed properties?
So see, what you can will as what is yours. What is not yours, you cannot will, you cannot gift, you cannot do anything about it, right? So when you are willing or when you're thinking of giving something by way of a will to as regards a disputed property, you need to set out in there that, see, there are certain disputes as regards this property. If this property eventually, by way of law or by way of settlement, becomes the property which I was entitled to, then this property will devolve in this particular manner. Right? You can even set out that I would want to keep aside certain funds from my estate to make sure that I defend this property till the time it is defendable. Yeah, you can do that as well.
Okay. We have a question that if someone passes away without making a will, what would happen to the property or assets of that person? I think that was already explained in your slide.
Yes.
There's a second part of the question.
Yeah.
How do we know of all the properties that the person had?
See, all the properties the person had, I'm sure all the family members know as regards what is a property or what are the properties you had. And supposing you haven't done that, I think there should be one person in your family at least to whom you set out that, see, these are my estates, this is my asset, this is where I have bank accounts, this is where I thought of buying a flat, I've entered into say for example, an agreement for sale as regards this particular flat. So it is only the testator or the person who is concerned over here who will know as to what are the assets, right? So of course, if you do not know and you have a doubt, you can always write to the bank. Say for example, it's a bank account. You can always write to the bank stating that, listen, is this gentleman, did he have any account here? If so, what is the balance? I'm the executor of the will, and all this is the responsibility of the executor to figure out as to what for the assets.
So one more question: can an executor also be a beneficiary of the will?
Yes, the executor can be a beneficiary, but then the executor and the beneficiary then cannot be a witness to the will.
Oh, okay. We have a question from Ramesh Bhai Ved. What is the remedy for a beneficiary to know about the contents of the will and the implementation of the will?
Remedies is eventually you will need to go to the court to see any will, and I'm really sorry I could not bring that one slide. I don't know where it got lost in the entire presentation. That most of the wills need to be authenticated by the court, right? So if there is a will which is being authenticated by the court, you need you need to file a probate for that particular thing. Now, when you file a probate, there is something known as a citation. I'm sorry, I'm getting a little legal here, but there's a citation where either it will come in the newspapers or the person or the executors need to inform each and every beneficiary who will be affected by the contents of that will. So in that case, the will be there in front of you to see as to what are the contents of the will. That's one. Secondly, if you know that there is a will and it's not being produced and you know where the will is, you can go to the court and try and make an application to make sure the person with whom you believe the will is makes a statement to that effect.
Okay. We have a question from Pradeep Bhai. He wants to know, how can one pass on the rights of a rented property through the will?
See, a rented property through a will is something which, yes, you can pass on. However, under the Rent Act, right? If you have a commercial property or if you have a residential property, right? It depends. Now the person who is next of kin of you, who is living in that property or is using that particular property, becomes the tenant automatically. Like say for example, under the Maharashtra Rent Control Act, I don't know where this gentleman is speaking from, but under the Maharashtra Rent Control Act, under section 7, if you want to see, you can see that the person who is staying with you at the time of your demise, the closest relative, automatically becomes a tenant, right? So to will something by way of a rented property is may or may not be permissible, but if you got your next of kin living with you, it is automatically taken care of.
So the person has to be living with you. It can't be passed on to a person who's not staying with you?
No, it cannot be passed on to a person who's not staying with you.
This question from Jessica Negandhi,
Yeah.
that when a will is made, there are certain properties, assets, or different class of assets which are listed in the will. But over the lifetime or over a few years, all these assets would undergo changes. Some would be bought or sold. And finally, when the person expires, there may be a difference in the list, in the sense that the assets that he had listed when he made the will and the assets that he's leaving behind. In that case, what should be done? Should a person be continuously changing the will very often, periodically?
No, that's not what you want to do. Like, see, if there are and this of course depends from person to person, right? If somebody asks me that question, what should I do? I would say that only when it comes to your assets which are anything of relevance. Like say for example, you have a flat in Bombay and you sold off that flat and you decided to give that flat to your daughter, right? Only if you made some drastic change of that issue, you can make a codicil to say that this particular property has already been sold and accordingly, I want to give my daughter something else which has been bought in its place, right? However, many times also what happens is that people don't do that. When they don't do that, and giving you an example of a flat, that you had a flat, say for example, in Cuff Parade, which is in Mumbai. You sold that flat and you bought a flat at Mahalakshmi. In the will, you mention the Cuff Parade flat, but you not mention the Mahalakshmi flat. Automatically, it will be that you intended to give that particular flat, which is at Cuff Parade, to whoever, and then the beneficiary, be entitled to the Mahalakshmi flat. Right? So it all depends as to specifics.
And I guess this is where your rest and residue clause also comes into the picture for things which are not mentioned or come later.
Yes.
There's a slightly quasi-legal question. How can one identify suspicious circumstances arising out of execution of the will in light of the Supreme Court judgment on Kavita Kumar versus Pamela Mehta and others?
See, in that particular judgment, what happened is that the contents of the will was such that were not as per the wishes or as per what the testator used to mention earlier. Apart from that, what happened is that, see, the requirements of a will, okay, and to answer your question as regards how do you know that there's suspected circumstances. Now, suspected circumstances can be when a person was unwell, right? When a person was about to enter into the hospital, and that is the time when a person made a will. It could also be that because the person was entering into the hospital, wanted to make sure that everything is placed and has made the will. But people feel that no, this particular property, my mother had promised me, it should have come to me. How is it going to somebody else? There is something suspicious. Everything is going to one particular beneficiary. It's not going to the other. There's something suspicious. So suspicion is something which you cannot figure out. It is there in your mind, right? Sometimes the suspicion is well founded. Sometimes it's not.
Okay. Jayesh Bhai Bhatia wants to know: is there any time frame for the execution of the will?
Time frame for execution of the will? No, absolutely no time frame. There's no limitation. There is a limitation for filing the probate of the will, which is 12 years from the date of the death of the testator. But there is no time limit to having the will executed. No, none.
We have a question from Bijal Kanadi, that if the beneficiary were to die before the testator, then what happens? And we also have a question where it's asked that if the executor dies before the testator dies, then who executes the will?
Yeah. So see, this is where the professional executorship, etc., comes in. But in case you do not have a professional executor or anything like that, then you need to make an application to the court to appoint an executor, and people who are willing to be the executor for that particular will be appointed as per the directions of the court. That is one. As regards the executor passing away, as regards the beneficiary passing away, say for example, the property, say gentleman decided that he should give his property to his son. Now the son has died before him, right? And thereafter he passes away. Then depending on whether the son had made a will, if the son had made a will, the rest and residue of the property would go to the beneficiary, whoever he stated therein. If there is no will made by that son, it will go as per intestate succession. So it will devolve as per the rules of intestate succession.
Okay. We have a question from Preeti Ashar, that is there any validity to the will? That is, the property has been willed to me by my father, but for 2 years we haven't transferred it in our name yet. So can I do it now? Is there a time frame before
Yes,
which
of
I should
course,
do it?
of course, of course, of course. So you have a 12-year time period as per law. You can absolutely go ahead and do it, and it is advisable for you to go and do it right now, because you never know when you need to sell the asset, what you need to do with the asset, and the later you do it, the more circumstances will become suspicious as to why did you not do it at that time, especially for a buyer who wants to buy it at a later date. That why was it done after so many days and why not earlier, right? So it's much better to do it faster, the better.
One more question. When you are trying to transfer properties, there is a talk of a legal heir certificate or a talk of a succession certificate.
Right.
So are these two, legal heir certificate and succession certificate, the same? And or when is each one required?
See, a succession certificate or a legal heir certificate is required when there is no will. Yeah. Again, I'm really ruining the fact that slide did not come in place, because they had its terms that a succession certificate or a legal heir certificate will be required when there's no will. So you need to bring out from the court as to who your successors were in order to transfer the assets, right? If there is a will in place, then you have to apply for a probate, and once a probate is granted, you can work further. So it's just different names given to different circumstances. A probate or a legal heir certificate or a succession certificate.
Okay. One more thing. Now, when it comes to ancestral property, is there any kind of compulsory inheritance which is to be done for the ancestral property, or should it be treated like a self-acquired, self-earned property?
See, I tell you what, I will, please pardon me, but I will not comment anything on ancestral property at all. I'll tell you why. Because ancestral property, to determine ancestral property, there are various methodologies which you need to put in place. Once that ancestral property has devolved as per you, onto you, who else will be entitled to it? You know, ancestral property can be by way of a HUF, which is a Hindu undivided family. It could be even bequeathed generally. So please pardon me answering this question, because this is something that very case specific, and you know, any answer which I would give would not be justifiable right now. So I'm sorry for that.
That's fine, Ashish bhai. One more question. Is it mandatory to probate the will in Mumbai, or
Yes.
is having a registered will helpful for probation?
No, a registered will is helpful for probation if you feel that, yes, there is a dispute as regards that. However, anybody who's residing in Mumbai, Madras or Calcutta, or has immovable property situated in Mumbai, Madras and Calcutta, needs to have the will probated as per law.
Okay.
Right? So probate is necessary as per law.
Can you make a will for HUF property?
Yes, of course you can make a will for HUF property. There's absolutely no problem, because you are entitled to that. What is HUF again? Simple English term, Hindu undivided family, right? So
Yeah.
when you have the right over a particular share in that undivided family, when you have a right to the undivided share, you can will it the way you want, provided again it's not ancestral and, you know, somebody else does not have a right to it for some reason, etc. So the golden rule is that you can gift, you can bequeath, You can settle in trust whatever you are entitled to. What you're not entitled to.
So would I be right in understanding that each co-partner of the HUF can make a will of his share in the HUF property?
Yes.
Okay. One last question we'll take up, Ashish Bhai. Is there any stamp duty we have to pay if we register the will?
No, again, there's no stamp duty required. You need to pay the usual registration charges, which would be to register a will, which will depend from sub-registrar to sub-registrar. But there is no stamp duty payable. No, none at all.
Okay.
Yeah.
Okay. Thank you so much, Ashish Bhai. The session's been wonderful, and you've been patient enough to answer so many of our questions. I think wills and properties are such a matter. Once a person gets into it, the complications
complicated.
Coming in.
Complicated. Yeah. But trust me, it's very, very simple. If you keep it simple, it is simple. If you complicate it, yes, of course, it will get complicated. So that's my last parting sentence, as I can say it. Thank you very much, all of you, to have me here. I really appreciate the entire effort which the team has done. You had 3 Zoom calls with me earlier to make sure that everything is in place. And I really appreciate the effort which has been put on by all of you, especially for the Bhatia community. So thank you very much.
Thank you so much, Ashish Bhai. Our earlier 2 webinars were how to earn money after COVID. This is the first time we are talking of how to distribute the money after COVID.
Okay.
So thank you for the presentation, Ashish Bhai. Very lucid, and we have some more questions also. Some are a bit long, which we won't want you to take up right now. We'll mail them to you, and you can answer them, and we'll send it back to the audience. But thank you so much for your time. And I would also like to take this opportunity to thank Kaushik Bhai Sampat for having connected us to Ashish Bhai Bhakta.
Yeah. I kept on telling him that I hope I live up to your recommendations. So thank you very much, Kaushik Bhai. I really appreciate it. Yeah.
No, you lived up to our expectations and much more, Ashish Bhai. We are really happy that you could spare the time and come.
Thank you.
And this session is also being recorded live, relayed live on YouTube. And the recording will be available here. So for all the people who are seeing it, you can please pass this information on to your family and friends in case someone has missed the session and would like to see it later. You can definitely catch it on YouTube. It's on our channel, Drshtikon Talks. So you'll have to log in there with your Gmail ID to view this. Our next session will be on July 19th, where we'll be continuing with the Wonder Woman series, where we'll be featuring 2 Bhatia women achievers who will take you through their success journeys over the years. Meanwhile, if you have any feedback for us, please write into us at drshtikon.talks@gmail.com. That is drshtikon.talks, drshtikon.talks@gmail.com. We're very happy to have all of you with us, and we look forward to see you all again on the next seminar on July 19th. And from the Drshtikon team here, thank you so much, Ashish Bhai, and thank you so much to the audience. Meanwhile, please stay safe and stay healthy. Thank you.